Okay, so back again in the final segment of today's 2-hour broadcast. I'd love to just spend hours on this topic. We go through and understand it better, but as I've shared with you before, go back to the creation of the American Bankers Association, then the American Bar Association, and virtually and almost immediately thereafter the creation of this Commission on Uniform Law. And then we can understand a little bit better, after having read these quotations from the Sherman Antitrust Act, go back to Shakespeare, methinketh you protest too much. All right, cui bono, who benefits? Now listen to the next paragraph. And again, these encyclopedias articles are of the highest caliber. I've got 7 sets of encyclopedias, read most of them. And this particular set of encyclopedias is, as I said, of the highest caliber, more insightful than many. It is the Encyclopedia of the Social Sciences. It was ostensibly created as part of the Hochschule for Politik to help the German people get ready to, run the world almost. At least improve their situation. But clearly, now, here's the next part, clearly, the law was inspired by the predatory competitive tactics of the great trusts. All the way through Gustavus Meyer's History of the Great American Fortunes, all the way through that book, he repeats this theme. He keeps bringing it out and showing it and showing it and showing it again. From the very earliest times in this country, the colonies, themselves corporations, with charters from the crown lands, with charters, these chartered colonies. Just like all of the mandates that they had right up to the beginning of the Second World War. All of this, all right, from the very beginning has been a corporate adventure. There's no doubt about it. It's all been commerce. But what we've seen over and over and over again is that the governance of these colonies and of the towns and so on in the states and then the Fed and the judicial system and all of that is of and by and for the wealthy. That's right. We've never really had a constitutionally limited Republican form of representative government in this country. I think it's a laudable goal. I think it's an achievable goal, an attainable goal. But we really never had it. And if we ever did have it, it was such a fleeting moment that you could probably knock back about 3 tankards of ale in the hog back and go down with 1 big loaf of whole wheat bread and have experienced it all. But here again, clearly, the law, this is the Sherman Antitrust Act, was inspired by the predatory competitive tactics of the great trusts. Money buying the best congresswoers they can find. And its competitive system in industry, and its primary purpose was the maintenance of the competitive system in the industry. The evidence indicates no intention that the law apply to railroads, they were the chief actors of the day, already subject to the Act of 1887, and but slight appreciation, particularly among its supporters, to the significance of its broad terms in relations to labor organizations. Nevertheless, both railroads and laborers were later made subject to it by judicial rulings. This is like sweeping aside all of your competition. Vaguely worded, the varying subsequent influence of the Sherman Act was upon American industrial organization has depended mainly upon the cumulative interpretations of its meanings by the Supreme Court of the United States. We went away from common law and we went into this new system of codified, statutory, regulated privileges, licensable, taxable, and revocable. We went away from the common law of antiquity, our heritage. Went into this new process. With respect to the various types of agreements for raising prices above the competitive level entered into by independent enterprises, the Supreme Court, excuse me, has until recently uniformly found that they violate the Act and has thus served to reinforce the state laws in driving cartel activities into secret channels or subterfuges. It's very important to understand, because any of the little guys, any of the early, the entrepreneurs, they're the ones that the Karl Mordecai and Marx Communist Manifesto is focused upon. Yeah, workers of the world unite, all right. That's the antithesis. You've got capitalism on one side, you've got the workers of the world unite on the other side, but the goal is to wipe out the who? The entrepreneur, the middle class. Those people that are employing anywhere between 5 and 500 employees, that sort of thing. The Bill Gates in his garage that everybody's worried about. That's the goal. And these things can do that because they make it so bleeding hard. What if you were, we heard, from our caller earlier, Jeff, Massachusetts, following along the line of allopathic medicine as opposed to the American Medical Association's, he was going for homeopathic as opposed to allopathic. And it's important, right, from that standpoint. Because if you did, God forbid, go out and rummage about on your property and you come up with some herbs and you blend them together, you make an herbal tea, and you can just simply sip this tea, and you find that the herbs are commonly found in just about every part of the earth. You could simply sip this tea, and it would boost your immunity to a level that you'd be impervious to anything that was thrown at you. Why, that would have to be quashed. That would be crushed. They'd probably shoot you. Call you a drug dealer. A few leading cases in which activities of trade unions have been curbed have led to bitter opposition to the law in labor circles, particularly in view of its failure, as will be hereinafter shown, to prevent huge corporations from combining. So it all benefits the guys at the top. And why wouldn't it? They spent money, big money, to get it. It's a lot easier, rather than to take a few million of your own dollars and start a railroad, it's a lot easier to take those few $1 million and truck off to Washington and get Congress to steal it from the public treasury, steal it from the people to build your railroad, and give you far more than you ever could have with your own money. And this is the history of American governance. This is the history of the statutes in this country. It's easier to bribe Congress, it's easier to bribe the State House than it is to affect it from the outside. This is why we become vocal local, because we're going to need to stop this sort of madness right where we are. In our county councils, in our city councils, on the school boards, at the state level, the State House, the State Senate, governors, Attorney General. I think the most important office that's elected around here, besides the county committee man and county committee woman, is your county clerk. They stand between where we are and where we need to go again. Why? Because they control the elections. County clerk could line up all those Diebold electronic voting machines out in the courtyard of the courthouse and drive a fire axe right down through the top of them. Except from this day forward in this county, we're going to use paper ballots. We're going to hand count them. We're not going to let these ballots come out of the polls until they've been counted. We'll have the high schoolers come in and we'll give them all pizzas. They're going to have to count the ballots. Then we'll post the results on the door. But these ballots aren't leaving the poll until we know. And then somebody can call us in with a cell phone and tell us what the results are. And we'll have hand counted paper ballots in this country moving forward. These are things that we could do, and we can do them quickly. But again, with respect to the growth of proprietary consolidations in some form or big business, which undoubtedly constituted the principal target at which the Sherman Act was aimed, the history of its application is peculiar. At the time the law was passed, the great trusts were fleeing from the outlawed trust form of organization. Well, they're back again. Shared it to you right out of the Reader's Digest. Trusts, the foundations, Renee Wormser, their power, their influence. The Standard Oil Trust dissolved into a community of interest based on interlocking stock ownership until 1899, when a holding company was formed. The Sugar Trust went through a holding company form into a consolidated corporation. The Whiskey Trust went directly to the consolidated form. The new combinations, which sprang up in great number between 1897 and 1900, were almost exclusively corporate consolidations, mergers and acquisitions. Thereafter, the holding company form came into extensive use. We've talked about that power of the holding company. This whole movement was facilitated by the radical changes in the policy of certain states towards chartering corporations, exemplified in the New Jersey General Corporation Law of 1888, extended by amendments in 1889 and 1893, whereunder corporations could be organized with the widest latitude in defining their own powers, and especially with the full sanction for the acquisition of stock in other corporations. Moreover, these new style state and corporation laws gave slight ground for fear of vigilant supervision or effective control. There was then, as in 1934, no general, federal incorporation